Now, for the last 2 weeks, so we looked at the introduction of the book, so mainly looking at the setting up of a company, limited liability, and the importance of separate legal personality, why that's so important in company law, in cases like Salomon, and also looking at instances where the court would let all peers corporate. Now, what we're going to look at today is something called promoters and pre-incorporation contracts. Now, first of all, we're going to look at, well, first of all, what is or who is a promoter of a company? And more importantly, okay, what if this person calls a promoter enters into a contract on behalf of the company before it is actually registered? What is the legal consequences and legal significance of that contract? Now, first of all, who is or what is a promoter? Now, let's first define that. What happens is, before a company is duly set up or duly registered, very often there are some preparation works that need to be done. For example, the buying of equipment, the renting of office space. Now, that's what we mean by pre-incorporation procedure or status. Okay, so before the company, right? Before it is incorporated, before the company is incorporated, okay, those are usually the agreements or the procedures that a company may take for the preparation of setting up a company. Now, usually when that happens, okay, someone calls a promoter or a peer in the scene. Now, according to our 19th century case, Quick Cross versus Grant, okay, quote, a promoter, okay, is one who undertakes to form a company with reference to a given project and to set it going, taking the necessary steps to accomplish that purpose. Okay, so undertakes to form a company, okay? That's his main duty. Undertakes to form a company. Now, in a more modern case, 1950s case, okay, what the court said was promoters are persons who leave it to others to get up the company upon the understanding that they will profit from the operation, may become promoted. In other words, they're doing it, okay, for fee, usually for fee, for profit. Now, of course, in reality, what happens is, right, the promoter, as we'll look at later in many cases, the promoter also tends to be one of the major shareholders of the newly founded company. So, for example, if you and I, let's say you and I and a group of friends, okay, we decide to set up a company. Now, what usually what happens is, you may ask me or one of your other group members, who will also become the major shareholder, to act as a promoter. Okay, to rent an office space, to buy necessary equipment, etc. And by doing that, by taking upon that task, I become the promoter of the newly founded company. Right, so what is the duty and obligation of a promoter? Supposing you were asked to become a promoter for a company before it is officially registered. Now, what is your duty and obligation? Now, the duty and obligation of a promoter is similar to that of a fiduciary under a trust. Now, fiduciary duty includes, okay, if you set a trust, or when we look at directors' duties, include, right, duty of loyalty. duty of care. And more importantly, as we look at later, especially when we look at directors' duties, duty not to make a secret profit at the expense of your principals or your beneficiaries, the company. Now, this was first illustrated in a case called Goldstan versus Bonds, okay? It was a 1900 case. Now, what happened in this case was, right, the promoter of a company, they acquire a company intending its resale to the sale of shares in that company. So they brought this business, and then they wanted to resell this business in order to make a profit. Now, in doing so, the original directors made a substantial profit, which they did not disclose to the other shareholders and directors. Now, subsequently, what happened was the company, after it was set up, it later became insolvent. And the investors, the existing shareholders, wanted to seek repayment of this profit from the hidden profit. Now, what the House of Lords held was that, as promoters, they were under a duty to make explicit declarations of the profit which they made. Okay, so they made a profit by reselling the business. So according to the House of Lords, as promoters, okay, they were under a duty to make explicit declarations of the profits which they already made. Now, what if the promoter does not make a disclosure? Okay, what if the promoter does not make a disclosure? Now, if the full disclosure is not made by the promoters, the contract is, quote, voidable, okay, not void, voidable at the company's option. Now, voidable in the sense that, right, it is up to the company to choose rather whether or not to rectify that contract. Now, however, what the court also said was the right to rescind that contract or agreement will be lost if the company affirms the contract and if the company delays in exercising its right to rescind the contract. Now, also, okay, where the contract has been affirmed, okay, the company can still sue the promoter to account for the secret profit which he or she made. Yeah.
So could you repeat that one sentence? Could you repeat the last sentence?
Okay. Right. Okay, where the contract has been affirmed by the company, okay, where the contract has been affirmed by the company still reserves the right to sue the promoter to account for any secret profit made for setting up the company, setting up the business. Alright, so to put it simply, okay, what it means, right, if you're a promoter, in the course of helping to set up the company or the business, if you make a secret profit because of your promotion as a promoter, okay, the rule is you need to declare it to the other shareholders after the company is set up. Now, the company, okay, later, if it's duly set up, they can choose to rectify, okay, that agreement or contract which you enter into on their behalf. However, what you're not allowed to do, okay, is to make a secret profit for yourself at the expense of the business. Now, what if the promoter breached that duty? Okay, breached the fiduciary duty as a promoter. So what sort of remedies are available? Now, this was illustrated in a case, a 19th century case called Allender versus New Sonbrio, Prosper Company. Now, what happened in this case was, Mr. Allender, he was a banker. Okay? He was a banker, and he acted as a promoter to set up the company. Now, before the company was properly registered and set up, what he did was, he bought the lease of an island for, at the time, for £55,000. Now, what happened was, the company, New Sonbrio Phosphate Company, was later duly registered, duly set up. Now, 8 days after the company was duly incorporated, he then sold the island to the company for £110,000. Okay, so he bought it himself for £55,000, and when the company was set up, after the company was set up, he then sold the island to the company for £110,000, which means he made a profit of £55,000. Now, at the time, okay, it was quite clear that the board of the company was effectively controlled by Mr. Allender, and then they chose to rectify the deal. Okay? They chose to rectify the sale of the island to the company for £110,000. Now, as I said earlier, right, yes, a company can rectify that deal, right? By law, yes, the company can rectify that deal. Now, the issue before the court here was, right, he himself, who acted as promoter, actually made a profit of £55,000. Now, to cut a long story short, what happened was, okay, he then used his network, okay, to advertise and promote the business, and then a lot of shareholders chose to subscribe to the company. Now, to cut a long story short, what happened was, many months later, the investors, i.e. the new shareholders, they found out the fact that Mr. Allender had actually bought the island at half the price for which the company had paid for it. Now, what the company did was, they then sued Mr. Allender for rescission based on non-disclosure and wanted him to account for the profits. Now, the House of Lords unanimously held that as promoters of a company, you stand in a fiduciary relationship to the investors. Okay? As promoters of the company, you stand in a fiduciary relationship to the investors. In other words, as a promoter, you have a duty to disclose that you made a secret profit as a promoter and at the expense of the company. And more importantly, what they've also held that the contract can be rescinded. Okay? The contract can be rescinded. So in other words, the contract which the company bought the island for £100,000, okay, that contract, okay, can be rescinded at the option of the company. Now what happened was, right, the board rectified the deal, okay? The board rectified the deal whereby the company bought the island for £110,000. Now what the court said was, yes, number one, as promoter you owe a fiduciary duty, an obligation to the company, to disclose that you made a secret profit. And secondly, okay, the company can also choose to rescind the agreement which they bought the island for £110,000. Now, of course, as mentioned earlier, okay, the circumstances in which the company, i.e. the innocent party, may lose the right to rescission includes delay, which is a question of fact, okay? depending on how long it took them to discover. Affirmation, right, choosing to rectify or affirm the contract. Or in cases where restitution is impossible, where other third parties are also involved. Now, what about tortious liability? Can a promoter be liable in tort vis-a-vis the company? Now, we saw that as in Dalston versus Bonds, right? A promoter has to account for any profits made, any credits to the company. Now, what about for tort? Now, this was illustrated in a case called Leeds and Henley Theatre of Varieties. Now, what happened here was, right, the promoter, he sold a property to the company at an overvaluation, okay? It was later discovered, okay, the assets which he sold the company, okay, was an overvaluation. And the court held that this was clearly a breach of duty by the promoter. Okay? And the duty which he breached, duty of care, okay? As in tort. And according to the court, he was therefore liable to pay damages to the company due to the loss suffered by the company. Now, because what the court said was, right, as a promoter, right, as in tort, right, remember, your duty of care, okay, can rise but cannot fall. In other words, when you act as a promoter, even though if you're not a professional, you are judged by the standard of a professional acting in that capacity. In other words, if you choose to become a promoter, even though you do not have the necessary business skills or knowledge to do so, your standard, okay, your standard will be judged as if you are acting as a reasonable investor with professional knowledge and professional skills. So because that's in tort, right? Remember, standard can rise, but it cannot fall. Now, then of course, next question you might ask yourself, right? Why do we need rules on promoters and pre-incorporation contracts? Now, what is the rationale, okay, for having these rules to govern promoters and pre-incorporation contracts? Now, as I mentioned earlier, right? Because when you set up a business or preparing to set up a business, okay, there are a lot of preparation works that need to be done. For example, right, to acquire rights, properties, to borrow money on behalf of the company or before the company is duly set up. And the rationale for that is, right, from an economics or financial perspective, is to allow the company to start right away after it is duly registered. Now also, okay, before the company is duly set up, you also need to engage other professionals. Lawyers, accountants, for example. Now, because remember, right? A company when it is set up, duly registered, okay, it becomes a separate legal person. However, what if, okay, before it is duly set up, it enters into a number of agreements and contracts with other parties? So the question is, right, what is the legal significance of those contracts and agreements before the company was properly registered? Now we know that if it is a registered company, it has the right to enter into agreement with other parties. Now, what if, okay, 3 days before the company is duly registered, it enters into an agreement? Now, because in reality, before it is set up, right, before that company is set up, it has no legal capacity to do so. Which means it has to rely on somebody else to enter into those agreements and contracts on behalf of the company. Now, that somebody else, okay, is the promoter. And as I mentioned earlier, the promoter is usually, in reality, is usually one of the major shareholders or directors for the company that is about to be set up. Now, also, another reason for doing so is because there might be opportunities, business opportunities, before the company is duly set up, so the company wants to capitalize on that. So, for example, let's say there's a piece of land. Before the company is set up, and the directors, or the future shareholders or directors, think that the value of the land will go up by about 20%. In 2 months, let's say. So before the company is duly set up, okay, what they would do is they would ask the person, a promoter, to enter the deal for them. So once the company is set up, in say maybe 1 month or 2 months' time, they will then sell the land and make a profit. So commercially, okay, it is quite viable. Okay, it is quite viable to appoint someone called a promoter to do these things as well. And remember, once the company is incorporated, the company can choose to rectify all those things. And of course, 9 times out of 10, they usually would. Now, but then the question is, right, what if the company chooses not to rectify? Who is liable, or should the company be liable for those contracts entered into before the company was incorporated? Now, also what you need to bear in mind is, right, such contracts are often what we call incomplete contracts. So, for example, if a promoter enters into a contract on behalf of the company with a third party, okay, it would usually say the parties agree, subject to the company rectifying it. Okay, so the promoter and the parties agree to the terms and conditions of the contract and agreement, and then at the end it says subject to rectification by the company when it is set up, or something on those lines. Now, traditionally, under the common law, it is very difficult to recognize or fill in the gaps of these contracts, traditionally. Now, number one, okay, the rules of agency does not solve the problem if the rules are strictly applied. Now, number one, right, under the rule of agency, nobody can enter into what we call pre-incorporation contracts on behalf of the proposed company. Now, because the company does not exist, okay, so it is not a separate legal person, it has no capacity, which means, strictly speaking, it has no right to appoint an agent. Okay, strictly speaking, right, under the common law, because it does not exist, because it is not a separate legal person yet, so it has no capacity to appoint an agent on its behalf. Now, secondly, if we say that, okay, if we use agency law, if we say that it has no capacity to appoint an agent, then it would also mean that the company, strictly speaking, cannot rectify the pre-incorporation contract. Because it has no authority to appoint an agent, which means the agent who entered into the contract was acting outer rights. So if as a company, I did not authorize you to do so, okay, which means there is no contract, no agreement. So there is no contract for me to rectify. And if there is no contract for me to rectify, it also means, subsequently, if we apply agency law, strictly speaking, okay, there is no pre-incorporation contract. Now, if we apply strict agency law, okay, under the common law, okay, that would be the outcome. Now, what it also means, subsequently, okay, if we apply strict agency law, okay, it would be very commercially inviable. Because nobody, okay, if we apply strict agency law traditionally, right, it would mean that nobody would be able to, willing to agree with a promoter. Nobody would sign business or commercial deals with a promoter. And nobody would choose to enter into a contract before the company is duly set up. So from a commercial perspective, okay, it is not very economically viable. And that's why the common law, okay, in the latter part of the 20th century, okay, they came up with rules to protect the parties to allow these kind of contracts to take place. And that's the reason, okay, why we have promoters and pre-incorporation contracts. Now, the best case to illustrate this, okay, is the case called Kellner versus Baxter, okay, which was arguably, okay, the first case to define the duties of a promoter and to rule on the significance or validity of pre-incorporation contract. Now, what happened in this case was there was a group of company promoters for the setup of a new hotel. Okay, so promoters was helping to set up this new hotel business, and then they entered into a contract on behalf of the company. Now, at the time, the company was not duly registered. It was not properly registered yet, which means the company did not have the legal capacity. And the promoters then entered into a contract on behalf of this company not yet registered to purchase wine. Now, once the company was registered, it rectified the contract. Now, to cut a long story short, what happened was the wine was fully consumed before the full purchase price was paid. And then the company went into liquidation. Okay, so the promoters purchased wine on behalf of the hotel business. Yes, rectified the contract, but the full purchase price of the wine was not paid. And now the company went into liquidation. Now, of course, the seller of the wine, okay, then sued the promoter for breach of contract. Now, they argue, okay, the seller of the wine argued that the promoters were acting as the agent for the company not yet set up. Now, of course, the promoters counter-argue that liability under contract has now passed by rectification to the company and that they were not personally liable. Okay? So the seller of the wine argued that the promoter acted as agent. of the hotel that was not duly set up. And in return, the promoters argue the contract has now been rectified by the company, so liability for the breach of contract has now passed to the company. So they were not personally liable. Make sense? Now, what the court held in this case was, right, as the company did not exist at the time of the agreement, it would be wholly inoperative unless it was binding on the promoters personally, and a stranger cannot, by subsequent rectification, relieve them from that responsibility. Does that make sense? Okay, so the question is, right, so the question here is, right, so are the promoters still liable? Now, basically what the court said, yes. Okay, yes. Now, because according to the court, a promoter can only avoid personal liability if the company, after incorporating, the third party substitutes the pre-incorporation contract with a new contract on similar terms. Or in contract law, we call that novation. Or a promoter can also avoid personal liability on a contract if he signs the agreement merely to confirm the signature of the company and does not hold himself out as the agent of the company. Now, basically what the court says, right? To put it simply, okay? Mere rectification by the company after the company is set up does not relieve the promoter of personal liability. Point number one. Okay? Mere rectification by the company does not relieve the promoter of liability in contract. Point number one. Point number two, okay? The promoter can relieve itself of liability if the third party and the company replaces the original agreement on similar terms. In contract law, we call that novation. Okay, so a new contract replacing the original contract. And thirdly, a promoter can also relieve himself or herself of liability if he does not hold himself out to the other party as an agent of the company. Now, of course, in reality, right, if the company is still solvent, okay, if the company still exists, then of course the third party would, I believe, would sue the company. But what happened in this case was, right, the company, by the time, has already went into liquidation. So there was no asset left. So the only person, the only party he could have sued was, of course, the promoters. Now, of course, nowadays, okay, we have statutes to intervene in this kind of contract. Now, this is provided in Hong Kong under Section 122 of the Companies Ordinance. Okay, it says this section applies if a contract purports to have been made in the name or on behalf of the company before the company was incorporated. Subject to any express agreement to the contrary, A, the contract has effect as a contract entered into by the person purporting to act for the company as an agent for the company, like the promoter. So if you hold out somebody to be acting as an agent for the company, okay? the company is liable for that agreement. The person, however, B, the person is personally liable on the contract and is entitled to enforce the contract. Okay, the person is personally liable for the contract, entitled to enforce the contract. 3, after incorporation, the company may rectify the contract to the same extent as if A, the company had already been incorporated when the contract was entered into, and B, the contract had been entered into on the company's behalf by an agent acting without the company's authority. It goes on, right? Despite subsection 2b, if the contract is rectified by the company, then on and after the rectification, the liability of the person mentioned in that subsection is not greater than the liability that the person would have incurred if the person had entered into the contract after the company's incorporation as an agent acting without the company's authority. So basically, right, what this provision does is, right, it confirms the principles under Kellner versus Baxter. Okay, in other words, the person, i.e. the promoter, right, could still be held liable even after the company is set up and chooses to rectify the contract. So mere rectification of the contract itself, okay, does not relieve the promoter of personal liability. Now, then, you might ask yourself, right? If as a promoter, supposing I act as a promoter, or you act as a promoter, if I'm not resolved for personal liability, right, then why act as a promoter? Like, why ask yourself, right, is this rule actually fair? Okay, from the perspective of a promoter, is this rule actually fair? Now, the view of the court is traditionally, right, the promoter should still be held personally liable because in acting as a promoter, okay, they actually make a profit for doing so. They actually gain something. Now, because the traditional view is, right, if you do not gain from acting as a promoter, why would you act as a promoter in the first place anyway? Now, this was confirmed under a case called Phonogram versus Lane, okay? Or we call it the principle of personal liability of promoter. Now, what happened in this case was a person was attempting to form a company which was going to run a pop artist group. Okay, so decided, okay, to set up a company, and the purpose of that company was to run a pop band group. And in doing so, he managed to arrange financial assistance from a recording company. Okay, so he contacted the recording company, and the recording company provided him with the financial assistance to set up the company and to set up the pop group. Now, to cut a long story short, what happened was the company never came into existence, and the amount was later due. Now, what the recording company did was they brought in actions against the person who represented the unformed company, i.e., in this case, the promoter. And the court, here, the Court of Appeal, they confirmed the principle in Kellner versus Baxter and held that the promoter remains personally liable for the pre-incorporation contracts. This principle is known as the promoter's personal liability principle. Now, okay, the promoter is personally liable, okay, if the contract was made on behalf of the company, right? That's what the act says, okay? On behalf of the company. So the next question is, right, what do you mean by on behalf of the company? Of course, the most significant case, okay, is where the company gains from that agreement. Okay, if the company makes a profit from that agreement, yes, of course, that's on behalf of the company. Now, as we'll look at later on, right? Number one, you need to establish, okay, as we'll look at later on, okay, where the contract's made, okay, there is sufficient identification of the company. In other words, okay, the promoter was not entering the agreement on his personal capacity, but there is evidence to show that the contract or agreement entered into, okay, has sufficient link or identification to the company about to be set up. Or we call that a sufficient identification principle. Now, other controversies of this personal liability principle is, what if, okay, the contract, as we'll look at later, entered on behalf of a shell company? Now, what if later the company changes its name? Okay, let's suppose I was going to set up a company and I wanted to call it ABC Company, let's suppose. Before the company was duly set up. Okay? And then the promoter enters into that contract on behalf of ABC Company. Now, let's suppose at the time of registration I decided to change name to BCD Company. The next question is, well, is the company liable? Or is the promoter personally liable? Now, because if the name does not exist, right? Supposing it was BCD Company, subsequently. Now, BCD Company at law cannot rectify a company for ABC Company because it does not exist. Now, in that case, would the promoter still be held liable? And as we'll look at later, right, there's also the UK case of Catronic situation. And we'll look at what that is, okay? Catronic situation. Which was named, of course, after the case of Catronic versus Izzoni. Now, the controversy surrounding a shelf company, okay, was illustrated in the case of Okosh versus Den Marble Company. Now, what happened in this case was, okay, the company was originally incorporated in 1979 under the name Egomit Limited. Okay? Under the name Egomit Limited, E-G-O-R-M-I-T Limited. Now, for some reason, by a special resolution in 1980, it's changed its name to Den Marble Inc., Den Marble Incorporated. And then thereafter, traded under that name. Okay, traded under the name of Den Marble. Now, the problem was that the certificate with the company's new name, for some reason, was not issued until 1985. Okay? The certificate with the company's new name was not issued until 1985, until mid-1985. Now, but what happened was, in 1984 and early 1985, the plaintiff has supplied goods into the business which had not been paid for. Okay? He supplied goods to the business which had not been paid for. Now, what he did was, the plaintiff, Akosh, he issued a writ against the company and a director of Denmarble for payment. So the issue before the court was, right, is the company liable? Okay, it was called Ergomed Limited before 1985, and it was only officially changed to Denmarble Inc. in mid-1985. And the goods were supplied to the company in 1984 and early 1985 before the official change was actually made. So the question is Denmarble, i.e. the newly registered company, or the new name, okay, is Denmarble company liable for the contract? Or is the promoter personally liable for the contract? Now, because the issue before the court was, right, the one argument used by the defendant was, right, Denmarble didn't even exist in 1984, 1985. How can you hold the company liable? Now, what the Court of Appeal held in this case was, right, on the facts, the director of the company was not personally liable, okay, i.e. the promoter, they were not personally liable on a transaction entered into between change of name and receipt of the incorporation certificate. Okay, the director and the promoter, they were not personally liable on a contract entered into between change of name and receipt of the incorporation certificate. Now, what the court said was, right, a company which is waiting for a certificate of incorporation to change its name is not a company which has not been formed. Okay? A company which is waiting for a certificate of incorporation to change its name is not a company which has not been formed. In other words, where the business is only waiting for it to change its name, okay, at law, we still recognize that as an existing company. So in other words, the directors and the promoters, okay, are not personally liable during the gap period waiting for the company to change its name. Does that make sense? Right, okay, we'll take a short break and we'll come back and continue to look at the other things.
哇！呢13塊。